Lynn Kenyon, Everything Montana Real Estate, in conjunction with Live in Montana Real Estate. This is our whole series on everything related to real estate. Today we are with Brian Lee. Brian is an attorney in Shelby, does all kinds of aspects, does a lot of real estate. We're going to do 3 segments today. We're going to start with seller financing, because I get a lot of people, especially on weird rural properties or something that's not going to finance easily through a bank. We've done a lot of financing videos. This is, if that doesn't work, and sometimes the seller wants seller financing, they come to you.
Correct.
And what are their options?
So typically the reason sellers come to the attorney to get assistance with seller financing is because, like you mentioned, they can't get a commercial lender to fund the project. Or they may just want to control their receipt of the proceeds from the sale to minimize a tax liability by spreading the purchase price payment out over a period of time. So options for seller financing, you typically have 2 choices. There's one which involves like a written promissory note and then either a deed of trust or a mortgage to secure that note. The other option, which is less preferred, is a contract for deed. Those have become less favorable with title companies because of complications that arise if there's defaults, because under the contract for deed, actual ownership of the property does not transfer until the contract's paid off. Under the other version, with promissory note and a deed of trust, there's an actual deed that's signed by the seller at closing that transfers title, so the buyer owns the property. If there's a default, the seller's options are to foreclose under either the deed of trust or the mortgage.
Okay, now you sound like an attorney. in layman's terms, what does that look like for them? What happens in a seller financing scenario? They come to you, okay, I've got a piece of property, I've got this buyer, it's very complicated, I want to sell it to this person and they're just going to pay me. So the seller now is the bank.
Correct.
And how do you write a contract then that shows the expectations like you would in a loan document?
So
Typically?
just like a non-seller financing transaction, there should be a buy-sell or a purchase and sale agreement that sets out all the terms, purchase price, payment terms, things like that. But then it's usually coupled with additional documents like a promissory note and then something to secure that, a mortgage or a deed of trust or a contract for deed.
Got it. So why would a seller, what would be the risks to a seller? I'm doing a seller financing versus a traditional mortgage.
The risk to the seller in a seller financing situation is if the buyer defaults, the seller then has to exercise his or her remedies to basically either recover the property or have it sold at a trustee's sale or a share sale to try to make themselves whole. So the seller is on the hook for having to deal with that issue if the buyer ever defaults at any point until the entire purchase price has been paid.
So default for you is that they're not paying their mortgage. So just like you're supposed to pay mortgage, you treat it that way. So you're going to pay the seller every month a fee that you've agreed upon in the buy-sell based on your down payment, your percent. So that's all negotiable. And then if they default, I mean, they're going to go hire you again to sue the person who defaulted, or how does that work?
There's a couple options depending on the type of seller financing that's provided. Under the contract for deed, since the seller doesn't actually transfer ownership of the property until the contract is paid off, theoretically the default procedure is much simpler. There is usually an escrow involved that's holding an original conveyance from the buyer back to the seller, and the seller is required to give the buyer notice of default, and if the buyer doesn't cure the default within the time period provided in the contract, then the seller can contact the escrow agent and notify it that there's been a default and it hasn't been timely cured. And then the escrow agent will release all the documents in escrow back to the seller, which includes the conveyance from the buyer back to the seller, which the seller then records, theoretically clearing the title of any interest that the buyer may have in the property. As I mentioned earlier, there are some complications with title companies and them recognizing that process as putting clear title back in the seller's name. Under the deed of trust or mortgage, the process is more complicated. I don't know, it's probably way beyond the scope of what we're doing today to describe.
And that's why they call you.
Yeah.
But so there are things and that's why every time I do a seller financing, I say a attorney will draft this. I don't care if it's a trust indenture or anything. Everybody needs to know their expectations and the pros and cons. advising them. I advise them, I'm sure you do too, really vet your buyer. So if somebody says, hey, I can't get a loan on something, that should be a flag. It's maybe not the property, it's maybe the buyer, they have bad credit, they don't have the down payment, something. And so I always say, vet this buyer. I just did one, I have one today. You talk to the buyer. You be satisfied because he's going to be paying you every month. You be satisfied with who this is and do they have the ability? Because you can take this down payment and then they default, and default means they're not going along with the contract. And then you got to go back to Brian. So now you've got a little bit of money on a down payment, but now you got to pay Brian to litigate it, to sue them for what they've agreed to do because they're not doing it.
So under a deed of trust, or you refer to it as a trust indenture, those terms are interchangeable. The distinction between that versus a mortgage is the remedies and what the parties have to do to get the property back. Under the trust indenture or deed of trust, it's a much simpler process. It's basically providing notice to the debtor that they've defaulted. You have to publish the notice in certain places in the county in which the property is located. And then there's a trustee sale that's held on a date, say 120 days from the date that the notice is first published. And then the seller gets the property back 10 days after that trustee sale occurs.
That's a lot easier.
The mortgage, on the other hand, is a much more complicated process. It generally requires that you file a civil lawsuit against the debtor and ask the court to order that the mortgage be foreclosed. And then once that process is complete, there's a actual process of setting a sheriff's sale. And that process is similar to the trustee sale in that there's a public auction that takes place and the borrower and any other parties that are interested can show up and bid. But once that process has occurred, the borrower retains a right of redemption for 1 year from the date of that sale to basically come up with the money and redeem the property.
That's a big deal. I've had that happen once. So they lose it, but they have a year to get it back.
Correct.
And that's only in a mortgage?
That's only under a mortgage. That's the trade-off between the deed of trust and the mortgage. The deed of trust, the true trade-off is under the deed of trust, the compromise that the legislature made is that the seller gets the property back more quickly than under the mortgage, and in exchange for that, the seller forfeits their right to pursue a deficiency judgment against the borrower if the property sells for less than what the seller's owed. Under the mortgage, if the property sells at the sheriff's sale for less than what the seller's owed, then the seller can go back to the court and obtain a deficiency judgment against the borrower and then pursue that separately from the actual recovery of the property and the sale through the sheriff's sale.
Makes sense. So in the olden days, like 10, 15 years ago, it was always attorneys. If you represented the seller, you wanted a contract for deed. And if you represented the buyer, you wanted a trust indenture, deed of trust. So it sounds like that's kind of changed a little bit, that there's a real more I'm sure there's some discretion on that you're wanting to see more deeds of trust because of that. It's simpler to cure a default.
From the seller's perspective, I think the contract for deed would be preferable because of the process of getting the property back more quickly. That doesn't eliminate the possibility that the title company in a subsequent sale may flag it and require the seller to complete a quiet title action to get true clear title to the property. So I think your assessment that the contract for deed is more preferable to the seller is accurate, and that buyers would prefer the deed of trust. The other distinction with the deed of trust and the mortgage is that you cannot use a deed of trust on property that exceeds 40 acres in size. So that limits you to only using a mortgage.
Yeah. So if you're totally confused, this is why every deal I say, an attorney's going to get involved with this is seller financing, because you need to sit down. If you're the buyer, there's an aspect. If you're a seller, there's an aspect. You need to know your risks. There are a lot of benefits like deferred capital gains. We just confirmed, and this is still the case. I had a client yesterday go to his accountant. Yes, you are not going to pay. So if you make $500,000 on a deal and you do a seller financing, some of those capital gains are going to be deferred. In addition, you have a mutual agreement on what your interest is. So if you're thrilled with 10% interest, you can negotiate that with the buyer. If he's willing to pay that, then you have that as a return for you. So there's a lot of things to think about when you're doing seller financing. There's definitely pros. There are some real pros. It's not just all, I'm going to have to deal with attorneys for the next 10 years till this is done. That's not necessarily the case, with all due respect. but it's something you definitely want to sit down with an attorney who can give you these pros and cons with your situation, your individual situation, and somebody who's done real estate and knows what they're doing. So super helpful. I think as interest rates start to rise more and more, we're going to see more seller financing deals. And don't say yay or nay. Sit down, visit with an attorney. If you draft one of these, it's not several $1,000s. Your loan fees are typically going to be about 3%, and that's the other thing I always tell people. So if you go get a loan, you're going to be about 3% to the lender, with all your prepaids and loan fees. If you do a seller financing, you're going to pay an attorney to draft it, and it's going to be, it depends on how complicated what's a range?
Realistically, $1,000, maybe more if there's some really complex provisions involving access issues and water rights and things of that nature, but it's significantly less than typical commercial financing costs.
Yeah, so if you have a $100,000 deal, just right off the bat, you're paying $3,000 just for the loan, where you're going to pay an attorney $1,000. And so, yeah, again, talk to somebody, investigate it. It's an option for you. A lot of times people are saying, "Will they carry?" You'll hear that. Will they carry? Those are terms we see when a seller decides to finance a property. So super helpful. I'm sure you get a lot of calls. Brian Lee's in Shelby, does a lot of real estate, and we're thankful. Thanks a lot for coming.
You bet.